I'm going to go over 3 quick hitting topics. The Pay Transparency Act, WSIB Benefits for chronic mental stress, and continuing compliance with what might be the dead Bill 148. One thing that I want to make very clear about the Pay Transparency Act is that it's for Ontario-based employers only. So come January 1, 2019, employers will be required to include information for expected compensation or range of compensation in any publicly advertised job posting. So compensation means, and I'm just reading the definition directly from the Act, all payments and benefits paid or provided to or for the benefit of a person who performs functions that entitle the person to be paid a fixed or ascertainable amount. So there are no actual regulations written on the Act yet, but in our view, this would mean something like, hey, $100,000 plus 25% bonus, you would need to indicate the range would be $100,000 to $125,000 in your publicly advertised job posting. One wrinkle to this new law, and it has a similar flavor to the AODA legislation that was rolled out a little while ago. Employers with more than 100 employees in Ontario will be required to submit to the Ministry of Labour an annual pay transparency report commencing on May 15th, 2020 for employers with 250 or more employees, and May 15th, 2021 for employers with between 100 and 250 employees. Again, regulations applicable to this Act have not yet been drafted, and there's very little in the way of guidance in terms of what categories besides gender for which employers must track differences in compensation and report them to the minister. As you can see on the slide, the Pay Transparency Act will prevent an employer from proactively seeking out compensation history of applicants. So you can't ask your applicant, hey, how much did you make before? We're just asking so we can comply with this law. Employers can ask questions about the applicant's structure, compensation structure. So, hey, were you making a bonus plus salary, or what was the makeup of your remuneration? Employers are not barred from using information that applicants may voluntarily give without prompting, or if they disclose their compensation, you can rely on that. Of course, employers cannot punish employees if they make inquiries about the Pay Transparency Act or tell a colleague about how much money they make. The idea being that information frees flowly within the organization, which prevents pay inequality. For employers, the implication here is you may want to consider checking your employment agreements or workplace policies about whether disclosure of salary between employees would be a violation of the agreement or the policy, so that if you need to amend it, so that you're not hit with an inadvertent reprisal claim. Penalties under the Pay Transparency Act. In addition to monetary penalties, the ministry will be able to publicly shame you like you're a Lannister on the Game of Thrones. Shame. Okay, that was good. There will be a 1-year limitation period on employer liability for breaches of the Act as well. All right, okay, so moving on to WSIB benefits for chronic mental stress. This new benefit is going to cause, if it hasn't already caused, quite a bit of confusion for employers and administrators in terms of its interaction with STD, LTD, and employment insurance. So getting right into it, there have been amendments to the Workplace Safety Insurance Act, which ultimately create a benefit for employees entitlement to benefits for employees pursuant to a chronic mental distress or stress. The key here is that it must be a substantial work-related stressor. So what does that mean? According to the WSIB policy interpretation, a work-related stressor will generally consider to be substantial if it is excessive in intensity or duration in comparison to the normal pressures and tensions experienced by workers in similar circumstances. So the most oft-cited example here is workplace bullying and harassment. Interpersonal conflicts between workers and their supervisors, co-workers, or customers are generally considered to be a typical feature of normal employment. Nancy, Lorna, and I fight all the time. Therefore, we don't, okay. Therefore, such interpersonal conflicts are not generally considered to be a substantial workplace stressor unless the conflict amounts to workplace harassment or results in conduct that a reasonable person would perceive as egregious or abusive. So I'll just take you through one quick example of what we've seen in the literature in terms of what might amount to a benefit for an employee under the chronic mental stress benefits. A line worker is subject to the demeaning comments from his foreperson on a regular basis and quite often in front of his colleagues, and develops an anxiety disorder as a result. So if this employee now goes out on leave on account of this harassment, the employer's obligation to report to the WSIB may be triggered, and this may impact your experience rating. So it's just something to keep in mind. These mental health injuries are something that will impact your workplace now. Examples that would not trigger WSIB benefits: a worker is not entitled to benefits for chronic mental stress caused by decisions or actions of the worker's employer relating to the worker's employment, including a decision to change the work to be performed, changing the work conditions, to discipline an employee, or to terminate an employee, their employment at least. This is important for employers to know so that you're not walking on eggshells when trying to manage your workforce. There's a level of reasonableness built into these amendments. So I just want to take a step back and talk about the employer's obligation to report to the WSIB, because these new mental health injuries will trigger your obligations under these reporting obligations. So what are the employer's obligations under the Act? The employer must report a workplace injury or illness to the WSIB within 3 days after learning of your worker's injury or illness, and now this includes a mental health illness or a mental health injury, if the injured worker requires treatment from a health professional, is absent from work, or earns less than regular pay. So now if you get a doctor's note from an employee and you think that the employee is going on leave on account of some workplace bullying or harassment, you might have an obligation to report to the WSIB. Again, potentially impacting your experience ratings. Other instances in which an employer must report to the WSIB, if the individual is still at work, they do not receive health care, they require modified work due to the health injury or mental health injury or illness, and they are getting modified work duties for at least 7 days or a prolonged period of time. In this instance, again, your obligations are to report to the WSIB. Again, these obligations may be triggered by a mental health injury. So as a result of these changes, there will be an impact on employers covered by the Workplace Safety Insurance Act. For example, there will be increased pressures on employers to address stressors in the workplace and create modified work opportunities that take into account psychological limitations. Employers with stressful workplaces should take steps to minimize the existence of a substantial workplace stressor in order to reduce the likelihood of a stress-related claim. So in this instance, you might want to draw your employees' attention to perhaps an employee assistance program, or draw their attention to mental health benefits available under an insurance plan. If you have an ongoing mental stress case, you should ensure that these cases are well documented, especially in terms of what the cause may be and what the triggers are, whether work or non-work related. Okay, so moving on to continuing compliance with Bill 148. And I chuckle when I introduce this because there's a chance that it won't be in place by the time I'm done my presentation. Okay, another one. I'm sure most of you in the room are aware of the Conservatives' government or their aversion to this bill and do away with some of its past and upcoming changes, and in particular their focus on the 2 paid sick days as well as the upcoming changes to the equal pay for equal work provisions. We're not sure where this is going to land, but to be clear, the Bill 148 is still law. It has not yet been overturned, despite mounting pressures from the Retail Council of Canada and the Ontario Chamber of Commerce. So I'm just going to rip through some of these. Effective January 1, 2018, there were new record-keeping requirements in connection with dates worked, vacation pay, and overtime. Effective Jan 1, 2019, employers will also need to track the dates and times that an employee was scheduled to work or be on call for, and any changes made to the on-call schedule, any cancellations of a scheduled day of work or scheduled on-call period of the employee, and the date and time of the cancellation. That was a mouthful. Don't try and take that in. We'll give you the slides. Okay, so now moving on to the equal pay for equal work provisions. The ESA already provided that an employer could not pay an employee of one sex at a lesser rate than the other sex when both employees perform substantially the same kind of work in the same establishment, their performance required substantially the same skill, effort, and responsibility, and their work was performed under similar circumstances, under similar working conditions. Pursuant to the new provisions, dealing with equal pay for equal work, employers are not permitted to pay employees who do substantially the same work for different rates of pay because of a difference in employment status. So employment status being casual, part-time, temporary, seasonal employees. All these types of employees will now need to be paid equally to full-time employees when performing substantially the same kind of work in the same establishment for the same employer. So for example, a part-time employee cannot be paid less than a full-time employee for equal work, or a seasonal employee cannot be paid less than a permanent employee for equal work. In order for work to be equal, employees must perform substantially the same kind of work in the same establishment. Their performance must require substantially the same skill, effort, and responsibility, and their work must be performed under similar working conditions. So some of you may have gone through this analysis recently with your summer students where you realize you have to pay them a bit more than you want to. What is key here and what matters most is the skill, effort, and responsibility that are actually needed for performing the job and not the stated job conditions or what's in the job offer letter. So this might be something employers want to consider when drafting job descriptions or putting stuff in the job offer letter about the job. You may not necessarily be able to rely on the job description or job offer letter when you're defending against a claim for equal pay for equal work. The rate of pay for purposes of equal pay for equal work provisions generally do not include vacation pay, tips, gratuities, expenses and travel allowances, and benefit plans or payment in lieu of benefit plans. Employees will be able to request a review of wages, and the employer must respond with either an adjustment or a written explanation as to why they won't adjust the wages. Again, employers cannot punish employees for making inquiries in connection with the new equal pay for equal work provisions. And we hope it's obvious, but you can't reduce someone's pay to comply with the equal pay for equal work provisions. Now here's where it gets a bit helpful for employers, and you can see in the small font on my slides, a difference in pay is permitted if it's based on the basis of a merit system, a seniority system, a system that measures earnings by quantity or quality of production, or any other factor other than a difference in employment status or sex. So I just want to run through a couple of examples to make sure everyone's listening. Probably aren't. We'll go through scenario one. I'll just give you a few seconds to run through this. And here's scenario two. So I can turn it over to the crowd. Who can get paid more? Jack, Jill, or Susan? Who has to be paid equally? You can shout out the answer. So who has to get paid equally? And who can get paid more? Okay, I'm not even going to go into the explanation because you guys are all geniuses. So, as mentioned, an employer may pay an employee with greater seniority a higher rate of pay than another employee of different sex or employment status for equal work if the difference in pay is based on a seniority system. So gave you the answer. So we'll run through a quick scenario here. An employer runs a basketball shoe store, literally only sells basketball shoes, and employs cashiers who perform equal work. All cashiers receive $1 per hour of a raise after the first year of employment. Can the basketball shoe store company pay a cashier in year one differently than year two? You guys cheated. Yes. Okay. So good. We're all experts under the equal pay for equal work provisions, and I don't mean to insult you with the simplicity of the examples. It's just to give you a flavor. If you have a more nuanced question, feel free to give one of us a call, and we'll happily direct it to Lorna. So some best practices for employers. As a best practice, employers who rely on an exemption to the equal pay for equal work regime, such as a seniority system or a merit system, should document the system and advise all employees how the systems apply to them. Employees are also encouraged to review their pay structures to ensure that they're in compliance with equal pay for equal work rules, develop a salary or wage rate grid that outlines the minimum and maximum rates of pay for each job, and advise employees of how they progress through the grid. Post the wages or scales for advertised job vacancies, and avoid asking job applicants about their prior compensation and benefits. All right, I'm just going to rip through some scheduling protections that may be upcoming effective Jan 1, 2019. Effective Jan 1, 2019, employers are required to pay an employee the equivalent of 3 hours of work if you cancel their scheduled day of work or scheduled on-call period within 48 hours before the time the employee was to commence work or commence being on call. The obligation does not apply if you're unable to provide work because of a fire, power failure, storms, or similar circumstances beyond your control. Similar circumstances beyond your control is difficult to interpret. We don't have actual guidance on that, but if you think about it, maybe the Leafs or the Raptors or the Jays, they win the championship. You don't want to show up tonight. You don't want to show up to work the next day. You cancel everyone's shift. In that instance, you don't have to pay everyone. I'm just dreaming. Yeah, that one didn't go over well. Okay, thanks, Lorna. Also effective Jan 1, 2019, employers will need to pay an employee for a minimum of 3 hours of wages if an employee is required to be present or present him or herself to work, but works for less than 3 hours. The amendments eliminate the confusion about how an employee is to be paid under the 3-hour rule. The amendments specify that it's the regular rate of pay to which the employee must be paid. Also, effective Jan 1, 2019, employees will be afforded the right to refuse requests or demands to work or be on call on a day that an employee is not scheduled to work with less than 96 hours of notice, which is a fancy way of saying 4 days. Also effective Jan 1, 2019, employers will be required to provide a minimum of 3 hours of work if an employee is on call but is not required to work, or if the employee does work but does so for less than 3 hours despite being available to work for longer. This requirement may significantly increase the labor cost to some of the businesses with a high on-call workforce, for example, off-hour IT services that are regularly scheduled to be on call. So something to keep in mind effective Jan 1, 2019. Lastly, effective Jan 1, 2019, an employee who has been employed with you for at least 3 months may submit a request in writing for changes to his or her schedule or work location. As an employer, you are required to discuss the request with the employee and notify the employee of your decision within a reasonable time frame. If you deny the request or any part of it, the notification must include reasons for the denial. And again, non-compliance for contravention of the Act includes public shaming by the Director of Employment Standards, as well as monetary penalties. So that's it for me. Thanks for listening, and I will turn it over to Alex, who will go over some additional legislative updates and case law updates.
So good morning, everyone. Today I'm going to be talking about 3 quick topics. The first, we're going to start with an update on the accessibility front. Then we'll discuss some new rules for police record checks, and then talk about some notable Ontario cases from the last year, specifically on suspensions without pay, damages for loss of bonus, and termination provisions, which I know is everyone's favorite topic. So first, what's new on the accessibility front? All organizations with 20 or more employees in Ontario should have filed their compliance report by the end of last year. If you haven't, as you can see, the penalties range from $500 to $15,000 for failing to file. We understand that M&P has been retained to conduct certain spot audits, and these spot audits have been on various aspects of AODA compliance, including the existence of a feedback process and notifications to the public or successful applicants about accommodation policies. And federally, the Parliament has introduced Bill C-81. Bill C-81 will enact the Accessible Canada Act. The ACA has just passed its second reading, and it's been referred to committee. If passed, the ACA will only be applicable to federal organizations. At the moment, the legislation is very bare bones. Like in Ontario, much has been left to the regulations. However, Parliament has suggested that the AODA will be used as a model. Currently, the bill provides for 3 duties for all regulated entities. The first is accessibility plans. Regulated entities will have to create accessibility plans in consultation with people with disabilities. These plans would describe their strategies for improving accessibility and meeting their legal duties, and the entities would then have to publicly publish these plans and let the Government of Canada know when they're published, and then update them every 3 years or sooner if there's any new rules. The second is feedback tools. Regulated entities will have to set up ways to receive and respond to feedback from their employees and from customers. Feedback could include complaints about how an organization is fulfilling its accessibility plan or perhaps barriers encountered by individuals. And the last is progress reports. Regulated entities in consultation with people with disabilities would need to prepare and publish progress reports that detail how they fulfill their accessibility plans. In the report, they would have to explain how they consulted with people with disabilities. The progress reports would describe the main concerns of the feedback they received and how they responded to it. And so for those provincially regulated employers in the audience who I'm sure are smiling, we flagged this to show a willingness of other jurisdictions to start adopting Ontario's model. And so we might see this start arising in other provinces. So next is on police record checks. And we have some new police record check legislation. So the Police Record Checks Reform Act received royal assent on December 3rd of 2015, so nearly 3 years ago. And it lay dormant for several years, but then was returned to life by the Liberal government on April 25th, 2018, coincidentally just before the most recent election. Historically, the process for police record checks has been quite scattered and disconnected, with different police precincts doing essentially whatever they wanted. Often these checks included more than just convictions, and they would disclose records of things like suicide attempts, mental health detentions, complaints where charges were never actually laid, withdrawn charges, and even acquittals. The legislation standardizes the process by defining 3 types of police record checks: criminal record checks, criminal record and judicial matters checks, and vulnerable sector checks. So I'll take you through each one. Criminal record checks are going to contain criminal convictions and findings of guilt under the Youth Criminal Justice Act. So that's sort of your baseline criminal record check. The criminal record and judicial matters check contains everything that was in the criminal record check and also contains information on outstanding charges, arrest warrants, certain judicial orders, and conditional and absolute discharges. And last is the vulnerable sector check. The vulnerable sector check will include everything in the criminal record and judicial matters check, but will also include findings of not criminally responsible due to mental disorder, record suspensions or pardons related to sexually based offenses, and non-conviction information related to the preying on children or other vulnerable persons. So where the charges were withdrawn, dismissed, or stayed, or even resulted in acquittals. A vulnerable sectors check can only be performed when an individual is in a position of trust or authority over a vulnerable person, like a child or the elderly. So outside the vulnerable sector check, the Act actually specifically restricts the disclosure of non-conviction and non-criminal records, as well as mental health information. Probably most importantly, the Act contemplates a 2-stage process for employers to obtain a police record check. After consent is granted, the information is first disclosed only to the individual subject to the check. And after receiving that information, the individual has an opportunity to review and decide if he or she consents to the criminal record check being provided to the employer or prospective employer. And so what does this mean for employers? First, you should really give some thought as to whether you should be conducting any criminal background checks. Often employers are requesting it as a matter of course, without much thought as to their reason or rationale for it. You'll need to balance the procedural delays that will be caused by the new 2-step process and the value of obtaining knowledge about the individual's potential criminal history. And if you do decide that a criminal record check is necessary, you'll want to review your process to ensure that it is compliant. If you have one, you should be speaking with your background check provider to discuss the steps that they are taking for compliance. And if you don't have a provider, it might be a good opportunity to get one, but otherwise you should be reviewing your internal policies to ensure that you are complying with the 2-step process. And lastly, you should give some thoughts as to what level of information do you require. Is it the criminal matter check, the criminal and judicial matters check, or the very exceptional vulnerable sectors check? Remember, with every background check, criminal or otherwise, sometimes less information is more. if it means avoiding information related to code-protected grounds. And so lastly, we'll talk about some notable cases from 2018. So I've grouped our cases into 3 topics. The first is suspensions without pay. In the complex services case, the employee was employed as a shift supervisor at a casino, a security shift supervisor. And the employee was immediately placed on a suspension without pay after the OPP advised that he was under criminal investigation for workplace theft, that investigation was ongoing and that no charges had been laid. Charges were in fact later laid against the employee, but they were withdrawn. And despite being cleared of the charges, the employee gave up his gaming registration, which was necessary for his provision. So the employer advised him that his employment was at an end, which is what prompted this case. The employer's handbook expressly permitted the use of unpaid suspensions. However, even if a handbook or contract of employment says that an unpaid suspension is within the complete and utter discretion of an employer, it must still act reasonably. In this case, the court held that the employer had actually not acted reasonably. At the time when the suspension was imposed, the OPP investigation was in its early stages. It wasn't clear that charges would be laid or when, and the employer couldn't provide any other justification for why the suspension should be without pay. So some tips for unpaid suspensions. As we know, suspensions without pay are inherently risky. They often carry a risk of constructive dismissal. An unpaid suspension violates the implied term that an employer will provide an employee with work in exchange for compensation. And in situations of constructive dismissal, an employee is entitled to resign and claim his or her termination entitlements. There may, however, be situations where an employer would be permitted and, in fact, perhaps well advised to suspend an employee without pay. However, the employer must clearly and explicitly include an ability to suspend without pay in employment agreements and/or workplace policies, and must always act reasonably. So this is one of those cases where I suggest the employer carefully consider their options. Is a suspension without pay really necessary? Would a suspension with pay achieve the same goal, or is a suspension even necessary at all? And I always think this is one that's a good one to obtain some form of advice on because of the ramifications. And so next we'll talk about damages for loss of bonus, which has been a little bit of the bane of existence for defense counsel lately. So, interestingly, the case is Bain. That was not planned. In the Bain case, the employee's employment was terminated prior to the date the bonuses were paid out. There was a deferred portion of the bonus, and the employer put forward 2 arguments. First, that the employee was entitled to damages for the lost bonus only in respect of the amounts he would have received prior to termination and during the notice period. And second, the wording of certain provisions in the bonus plan excluded that deferred portion of the bonus from the employee's damages. The court held that the employee had earned the bonus. The lost bonus was an integral part of the employee's compensation, and there was no language in the bonus plan that altered or removed that right to compensation. The fact that the shares in this case had not vested was not sufficient to disentitle him. So the decision makes it clear that an employee may still be entitled to damages for loss of bonus that they would have earned during the notice period, even if that wouldn't necessarily have been paid during the notice period. And so next is the Singer case. In the Singer case, the employee took the position that he was entitled to be compensated for loss of bonus during the reasonable notice period. The employer took the position that it was the company's policy not to pay bonus after the employee's employment was terminated. Again, the court held that the bonus was an integral part of the compensation package and that there was nothing explicit in the bonus plan or employment agreement that restricted any entitlement. So orally understanding, having a general understanding was not sufficient. So again, wrongful dismissal damages in the case included compensation for lost bonus. So a few more takeaways. We found that the courts are reluctant to disentitle employees to a bonus just as a result of an employer's decision to effect what is a timely termination, one that just so happens to avoid payment of a bonus. It's often insufficient to simply indicate that a bonus is discretionary, This is something that we hear all the time in frankly, every case. However, as we start to review the terms and dig into them, we discover that the bonus isn't actually all that discretionary after all. It tends to be based on certain terms, achievement of goals, etc. To eliminate a bonus entitlement during the reasonable notice period, clear and unambiguous language is required. So what should you do? You should review your current bonus plans and employment agreements with respect to the bonus payments. Are they clearly drafted? Are they in compliance with the employment standards legislation? And does it clearly state whether bonuses are discretionary or non-discretionary based on goals, how they may be calculated, if performance issues with the employee will be taken into account, and whether there is any or no entitlement to a bonus over the common law notice period? And so lastly, as I said, this is everyone's favorite topic lately, termination clauses. You'll recall that these have been a constant source of grief for employers over the last decade. However, I'm going to tell you we're starting to see some light at the end of what's been a very dark tunnel. In the IBM case, the provision entitled the employee to the greater of 1 month of salary or 1 week of salary for each 6-month period up to a maximum of 12 months. The provision then red circled that entitlement, and by that I mean the statement that the amount is said to have included all entitlements under employment standards legislation. Those that have been following along with the case law will know that this is a bad termination provision. It doesn't explicitly contain reference to a benefits continuation, but then suggests that it provides all entitlements. However, it was the employer's next provision that turned out to be a bit of a saving grace. The employer included a fail-safe provision, which essentially said that in the event of the employment standards legislation providing a superior entitlement, IBM would provide those entitlements in substitution. So the court held that when read as a whole, the termination clause was clear, and it did comply with the ESA. The fail-safe provision clarified that any portion of the termination clause that fell short of the ESA would be read up into compliance. So the Burton case is similar. Again, it provided a bit of a questionable termination clause. Severance pay, no mention of notice of termination of pay in lieu, no mention of benefits, and not even a clear contracting out of the common law. However, the employer in this case also included a saving provision. And you can see it if the amounts to which you would receive upon a non-cause termination are less than the amounts to which you would be entitled under the ESA, you shall be entitled to notice, severance pay, and any other payment required by the relevant legislation. So again, the court held that this clause was enforceable. The termination clause's reference to the minimum notice required by the ESA was found to be sufficient to displace the employee's common law entitlement. And the requirement to provide any other payment required by legislation was found to be broad enough to satisfy all requirements. Interestingly, the court said that that would even include the benefits continuation. So some takeaways for employers. The first question is always, why do we care? The risk is, of course, that if any employment agreement or termination clause is unenforceable, the court will imply that term of reasonable notice. The employee will be entitled to reasonable notice upon a termination without cause. As we know, there's a significant gap between the ESA's floor and the common law's soft maximum. And just for clarity for those in the room, the ESA stretches to 8 weeks of notice or pay in lieu of notice, as well as benefits continuation. And for those employers that are required to pay statutory severance pay, up to an additional 26 weeks. The common law, on the other hand, has a soft cap maximum. We have seen higher awards in some circumstances, but the soft cap maximum of 24 months. So we can see there's a big distinction between a cap of 8.5 months if you're a severance pay employer, or 2 months if you're not, and the 24 months. So employers should review and update their termination provisions in their employment agreements frequently, and include a properly drafted fail-safe provision. This will also help protect against future changes to the legislation. That being said, we do want to give some caution about the use of fail-safe clauses. While they were successful in both of these cases, we wouldn't want you to consider them to be a license to simply write whatever you want and then rely on them to fix any deficiencies. In both of these cases, the clauses were subject to what I would consider relatively minor deficiencies. So I'm going to end by talking about some tips for remedying some existing deficiencies for those in the audience that are now sweating. For new hires, be proactive and have your templates reviewed regularly. For example, on an annual basis or when you're making a new hire. And ensure that the templates are actually being properly used. And this is one that I see a lot, where an employer uses an Ontario-based template for a BC employee, or the section is referenced to be Section 10 is the termination section, and it is in fact Section 71. For those existing employees, identify those gaps as soon as possible. It's always better to know than to not know. It lets you be prepared. But remember that deficiencies may not always be readily apparent. An agreement may be deficient, for example, if it was entered into with a lack of consideration. If you're in doubt, it's a good opportunity to consult with counsel. Consider whether implementing these new agreements is actually cost effective. It can often prove to be difficult and costly to have an existing employee execute a new agreement. Sometimes they're quite resistant to the idea. Support all new agreements with proper consideration. So for example, a signing bonus or a promotion, consideration being that thing that is exchanged between the parties. And incorporate revised agreements as part of your succession planning. A promotion often represents an ideal opportunity to put a new agreement into effect. It gets your rationale for the agreement and the consideration at the same time.